Chatty, hello world. This is Attorney Angel and I'm your legal angel. Hi my fellow angels. I know that it's been months since my last vlog and I hope that you're still staying safe, healthy, and well and that you're not forgetting to pray. Medyo busy po tayo sa dami ng mga kaganapan. But now we're back and we're now on our 970 plus subscribers. Okay, on the road to 1,000, konting-konti na lang. So, thank you very much for your support. And please spread the word. Share the word, like, subscribe, share, and follow. And for today, another learning video for everybody. Okay? So, see you later and I hope you enjoy watching and listening and I hope you learned something from this. Hello once again, this is Attorney Angel. Let's talk about disbarment and reinstatement under the subject of basic legal ethics. And I would like to thank my former students, headed by Mr. Sef Gozon, for allowing me to use their infographics for purposes of this vlog. So let's start. Let me begin by quoting the Supreme Court in Molonta versus Castillo, 240 Scra 310. The practice of law is not a right but a privilege bestowed by the state on those who show that they possess and continue to possess the qualifications required by law for the conferment of such privilege. We also know that the legal bases are contained in the rules of court and rooted under the 1987 Constitution under Article 8, Section 5, Paragraph 5. Important to remember also is that disbarment proceedings against lawyers are sui generis, neither purely civil nor purely criminal. They are in no way intended to be a criminal prosecution, in that it is not to inflict punishment on the lawyers, but these are investigations conducted under the authority of the court. Learned good moral character is a continuous requirement to be a member of the legal profession, to continue to be a member of the bar, and that the question that is going to be answered or the issue that is going to be answered in these investigations conducted is whether or not the attorney is still fit to be allowed the privileges under the legal profession and as accorded by the Supreme Court. Purpose of disbarment, it is intended to protect the court and the public from the misconduct of officers of the court, and also to protect the administration of justice by requiring that those who exercise this important function shall be competent, honorable, and reliable men in whom courts and clients may repose confidence. And this is also provided for in the case of Paras versus Villoses. 1 Scra 954. The common grounds for disbarment include deceit, malpractice, gross immoral conduct, conviction of a crime involving moral turpitude, violation of the lawyer's oath, willful disobedience of any lawful order of a superior court, corruptly or willfully appearing as a lawyer without authority, and practice of soliciting cases of law, among others. Disbarment proceedings may come from the Supreme Court or may be initiated motu proprio by the Supreme Court, or it may be by way of a verified complaint of any person before the Supreme Court or the Integrated Bar of the Philippines. And it is also important to remember that while the burden of proof is upon the complainant, respondent has the duty not only to himself but also to the court to show that he is morally fit to remain a member of the bar or the legal profession, and that mere denial would not suffice. So when his or her moral character is assailed, that his or her right to continue practicing the cherished profession is imperiled, he or she must meet the charges squarely and must present evidence to the satisfaction of the investigating body and the Supreme Court that he is indeed morally fit to have his or her name in the roll of attorneys. The power to disbar belongs to the Supreme Court, hence the power to reinstate likewise belongs to the Supreme Court. The Supreme Court has the exclusive power to reinstate a disbarred member of the legal profession. And this is again founded on Article 8, Section 5, Paragraph 5. To quote, the Supreme Court has the power to promulgate rules concerning the protection and enforcement of the constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Okay, so focus on the admission to the practice of law, which is under the authority and jurisdiction of the Supreme Court. Now, reinstatement. What is the purpose of reinstatement? As you can see on our infographic, the purpose or objective of reinstatement is to determine whether or not the disbarred lawyer is of good moral character, in the sense that he has sufficiently rehabilitated himself or herself in conduct and character. Okay. And it is applicable to whom? Reinstatement is applicable either to a lawyer who has been disbarred or Filipino lawyers who lost their citizenship. Okay. As to the process of reinstatement, the application is filed with the IBP Board of Governors. And within 15 days, it is forwarded to the Supreme Court. Note that no application should be considered for 5 years from the effective date of disbarment, and that the petitioner must show by clear and convincing evidence successful completion of the bar examination, compliance with all the applicable discipline or disability orders or rules, and rehabilitation and fitness to practice law. Now, in terms of lawyers who lost their Philippine citizenship and reacquired Philippine citizenship under RA 9225 or the Citizenship Repatriation Law, the conditions are set forth by the Supreme Court, and they can resume the practice of law under certain conditions, such as updating the payment of their annual IBP membership dues, payment of their PTR or professional tax receipt PTR, completion of at least 36 credit hours of mandatory continuing legal education or MCLE, and of course, retaking the lawyer's oath. And remember some guidelines in resolving cases of reinstatement that the Supreme Court will look for. Proof of remorse and reformation, sufficient time that has lapsed from the imposition of the penalty. Petitioner must show he still has or she still has productive years, showing of promise and potential for public service, and other relevant factors and circumstances. As for suspended lawyers, there is a definite period usually imposed by the Supreme Court or is imposed by the Supreme Court, and note that it is not automatic that upon the lapse of the said period that you're already with authority again to practice law. You will still have to petition the court for you to be allowed and permitted after your suspension to practice law. And that's it for this vlog. Thank you very much for watching and for listening. Be kind, be humble, be a blessing to others, and always remember to glorify God with a grateful heart. This is Attorney Angel, and I'm your legal angel. Sarangye!